Hi, I'm Mike Ungar, and I'm a pro bono volunteer with Legal Aid. You've taken a case, and you might have some questions. I'm here to reassure you that you can do it, and Legal Aid offers a lot of support. So thank you for joining Legal Aid's growing team of pro bono volunteers. Now let's get started. In this video, we'll cover steps to take in a lockout case. Time is of the essence in lockout cases, so you'll want to act right away. First, visit the Volunteer Resources page of Legal Aid's website to review materials that can prepare you to assist the tenant. Second, contact the client. Third, write a demand letter to the landlord to allow the tenant to return to the property. A police report can be made, but often police officers will not get involved. If available, filing a police report online is a good option and does not require police to come to the property. Sometimes a demand letter is all the landlord needs to let the tenant back into the property. If the landlord does not grant access to the rental unit within 72 hours or 3 days, you are now able to file a motion to get the tenant into the property. Most municipal courts have sample forms available on their websites. There are also sample motions on Legal Aid's Volunteer Resources page. Generally, you will have two options to achieve the client's goal of getting back into the property. You may either file a temporary restraining order or a complaint for injunctive relief, or in some jurisdictions, both. Depending on the jurisdiction, a hearing will be set, or you may have to file a motion for a hearing. At the hearing, you will be given the opportunity to explain the situation. Be prepared that the landlord may attempt to argue that rent has not been paid, that the property has been abandoned, or that the tenancy has been terminated for some other reason. For a property to be considered abandoned, a tenant must have clearly left the property and been away for 30 days, and the landlord must inform the tenant in writing of the intent to discard or sell a tenant's personal property. Be sure to have as much proof as possible that the tenant did not abandon the property or receive notice from the landlord. Even if a tenant has not paid rent, or there has been alleged termination of the tenancy for some other reason, the landlord must go through the court system to get an eviction before changing the locks. There are no self-help evictions in Ohio. If an injunction or temporary restraining order is granted by the court and the landlord still does not comply, a statement of failure to obey a court order can be filed, and a show cause hearing will be set by the court. It is also important to make sure that any rent owed is paid. If the rent comes due during the 3-day demand period, that rent should be paid directly to the landlord if he or she will accept. If the landlord will not accept, the rent should be paid into escrow with the court. Even if locked out, it is important that the tenant pays rent if there is an intent to return to the property, as this proves intent to continue residing there and does not put the tenant at risk for eviction. Tenants often ask about suing the landlord for the time they were locked out or any items that they lost as a result. Legal Aid can make referrals to private attorneys if a client is interested in suing their landlord. We hope this video helps you feel more confident about how to handle a lockout case. For more information and help, email Legal Aid or check out the resources on its website. And don't forget to report your volunteer hours. Thanks for joining us for this segment of Legal Ease, making pro bono easy.